Buckle up, courtroom watchers. This one's a powder keg. Today's case revolves around Justin Living, a man facing 2 serious felony charges, credit debit card abuse and burglary of habitation. The courtroom is tense, and right out the gate, we know we're in for a legal roller coaster. The defense wants probation. The prosecution is demanding a full 10-year sentence. And then comes the twist. Over 83 police reports tied to this man, allegations of threats, running from cops and hiding dope in a stranger's garage. Folks, this isn't your average criminal case. It's a deep dive into repeat offenses, broken second chances, and a justice system deciding whether redemption is even still on the table. Oh, and did we mention the homeowner had to hold him at gunpoint? Yeah, this isn't fiction. It's real, raw, and happening right now. Who's telling the truth? What does the law say? And is this a man ready to reform or just looking for another out? Let's Essex get into it.
Good morning, sir. You're Justin Living. And Mr. Living was previously here, entered pleas of guilty to the third-degree felony offense of credit debit card abuse and the second-degree felony offense of burglary of a habitation. The agreement was for a cap of 10 years to run concurrently on each. I've gotten the PS.
Let's break down this agreement. Mr. Living entered a guilty plea on 2 felonies, and the deal on the table is 10 years capped with the possibility of probation. The defense is pushing hard for a split, 1 conviction and 1 deferred adjudication, giving him access to treatment programs. Why does that matter? Because deferred adjudication means no formal conviction if he completes probation. But here's the kicker: if he violates it, the judge could hammer down a 20-year sentence. That's the legal gamble, rehab or repercussions. Would you take that deal?
The PSI, I'm sure the court has noted his felony criminal history. I would just note that just looking at it, there's a lot of material in the PSI, but in closer inspection, much of this was either refused or dismissed. I think it looks like what he has is, as far as felonies, would be a burglary of a building from 2012, possession, 2012, looks like it was probably a 1244. And then another state jail case from 2017, and then the case where he has his TDC time. The only TDC case back in 2017 was injury to a child, elderly, where he got 4 years TDC. So, as I said, first glance, it looks like he does have significant criminal history. I would take issue with the characterization and the recommendations that indicated that his criminal history has continued at a steady pace since 2001, since it looks like many of the felony cases were either dismissed or refused. Mr. Living, as he's stated in the pre-sentence reports, never had probation. In speaking with him, I think that he would benefit from the rehabilitative aspects of probation that are available to him. There's suggestion that he successfully go to the moral recognition therapy and successfully complete.
You've got to admire the defense's strategy here. They're not denying his past. Instead, they're reframing it. Yes, he's been in trouble, they admit, but many cases were dismissed or refused. The lawyer highlights moral recognition therapy, a structured program proven to help recidivists rethink their values and decision-making. He even notes family support as a backbone for recovery. The question here isn't whether Justin did wrong, it's whether he can do better. Can the court trust him with a second chance?
That would expose Mr. Living to the full range of punishment of 20 years. And then, of course, he already does have some state jail convictions, but the credit card abuse, again, is a third degree. So I believe that's just enhanced. The punishment range is just enhanced to a third degree, but the court could see fit to give him a conviction for that and still suspended and placed him on probation. But if the court does defer the burden of habitation, his punishment range would be 20 years if he does run afoul of probation instead of a 10-year cap that he's exposed to now. The court was just to refuse probation. So we asked the court to give him probation in both of these cases.
Thank you, Mr. Kimler. Mr. Nichols?
I'll disagree with Mr. Kimler's characterization as his criminal history not being that bad. You'll note that he's been mentioned in 83 reports by Belmont Police over the years, Your Honor. And he has continuously been violating the law since 2001. There's about 15 or 16, or at least a dozen misdemeanor convictions.
And boom, here comes the prosecution with both barrels loaded. They slam the idea that Justin's history is not that bad. With 83 offense reports, over a dozen misdemeanors, and victims too scared to press charges, they paint a picture of intimidation, manipulation, and relentless lawbreaking. The scariest detail: he was caught in a stranger's garage and had to be held at gunpoint. That's not someone just trying to change. That's someone who, according to the state, is a serious threat to public safety.
Which really doesn't give him too much credit here. His explanation of the other credit card abuse case is that he got it from a dope fiend. That's his explanation. So I don't see how probation really seems to be a logical or deserved option at this point. I think the 10 years is appropriate and sufficient to both protect the community and punish his repeated behavior. I'll note in the court, as part of our agreement, I'm dismissing a violation of protective order case. So I don't see why probation would even really be a consideration. And I'll ask court to assess the full 10 years.
Mr. Living wanted to address the court.
Here's where it gets emotional. Justin tells the judge, "I'm a good person, I can do probation," but look at the judge's face. She's not buying it. Why? Because actions matter more than words. In her eyes, a good person doesn't rack up 83 police reports. This moment shows the harsh truth of the courtroom. Redemption stories don't get written with promises, they're built through consistent lawful behavior. Can someone change after decades of criminal activity, or is it already too late?
Had an officer make the kind of statement in a PSI that I got in this one in a very long time. 83 offense reports have something to do with you in just Beaumont. Don't know where else you've been, if there's any others. 83. A good person doesn't have...
This is where the gavel drops. Hard. The judge is crystal clear. She's not here to gamble with public safety, and when she says a good person doesn't assault family members over and over again, you can feel the weight of years of frustration coming out. The law gives leeway, but there's a breaking point. Justin has hit it. The emotional tension in this moment is unreal. It's not just about laws, it's about trust, broken repeatedly.
That is not a good person. I understand you haven't had probation, but you were barely out of prison and off parole when you did this. I completely agree. I mean, Mr. Kimler's pointed out some decent things, but there is no reason whatsoever that I would put you back on the streets in this community for any amount of time that makes any sense to me. So in cause number 24, DCCR 0288, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of credit debit card abuse. Sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1100, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to 10 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence.
Let's break down what just happened. Justin Living is sentenced to 10 years for each charge, credit/debit card abuse and burglary, but they'll run concurrently. That means instead of 20 years, he serves 10. This is common in plea deals.
And obviously, you probably weren't. So anyway, that'll get signed. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a fiorm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Jacob Kozad?
Yes, ma'am.
Good morning, sir. You're Alejandro Uribe?
Yes, ma'am.
And Mr. Uribe, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for 5-year deferred adjudicated probation, and I received that pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge. Yes, sir.
So I guess my issues, or my only issue with going forward with this agreement is your status You're not here, or it appears as though you're not here in the United States legally, and that you've been removed before and there's an ICE hold on you now. Is that correct?
This next twist adds a whole new layer. A defendant on deferred probation while facing an ICE hold. Judge's reaction? Pure skepticism. And rightly so. Why grant probation if the person's about to be deported? This raises big questions. Is the system wasting resources? What happens if he returns illegally and reoffends? The judge doesn't sugarcoat it. She's following the deal, but she's clearly uncomfortable. This is the messy intersection of criminal justice and immigration law, and it's far from simple.
With the plea? I mean, if you do get out, so let's just do this. We'll just go forward with the plea, and then whatever happens, happens obviously in federal court or with any type of new charges over there. It looks like I have been handed an arrest warrant from the United States District Court, Eastern District. So I think you will probably be taken from here. If there's a hold on you, you'll go straight over into custody, federal custody, and whatever happens over there happens. What I'm going to do is go along with this agreement. I'm going to give you a probation. If for some reason you get out during this probation period and you're here in Texas, then you obviously are required to go to probation, do everything you're supposed to, because if you don't, you could end up in prison for a very long time on this case. So what I'm going to do is find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement, defer all proceedings, place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation if that becomes an opportunity for you. Obviously, if you do that, in this case, this is an excellent opportunity because you don't have this conviction on your record. And again, the other side of that, however, is if you do get out and you are here and you do not comply with the conditions of probation, you can be brought back into this court, found guilty of this offense, and sentenced anywhere in the range of punishment, which is up to 20 years in prison. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will go over your documents with you today, and then we'll just see what happens. All right, you can give that back to Mr. Coleman. Thank you. Good morning. Are you Demetrius Miles?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Your Honor.
Mr. Miles, in cause number 24 DCCR 2478, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from November 26th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state...
Here we see a clean-cut plea in action. Demetrius Miles pleads guilty to aggravated assault with a deadly weapon and gets a straight 10 years. No back and forth, no emotional breakdown, just the procedural gears turning. The key moment, the judge makes an affirmative deadly weapon finding. That label carries weight. It limits parole eligibility and marks the defendant as a higher-risk offender. In Texas, that's a big deal. Even with a plea deal, the consequences here are long-lasting.
Deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is Mr. Miles, is there any evidence of Mr. Miles not being competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Gabrielle Smith?
Yes, ma'am.
And Ms. Smith, you were previously in court and entered a plea of guilty to the second-degree felony offense of robbery. The agreement was for a cap of 5 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
I have, Judge, and if I may, for the court, my initial correspondence with Mr. Rojas was that she possibly had a tremendous amount of history out of Louisiana that I just couldn't get a grasp on based on the NCIC that I had. Obviously, now probation has successfully done that, and I'm not sure that coupled with her behavior in the jail is even
No,
appropriate for the 5-year sentence.
I
agree with you that it's not.
It's not, yeah. I don't think it is either. So, Ms. Smith, I mean, your criminal history is pages and pages long. Hold on.
I'm sorry.
You have felony 1, 2, 3, 4, 5, 6, 7. You have 7 prior felonies for theft of goods.
Judge, I think if you,
That's wrong.
I was going over the PSI with you yesterday.
No.
By my count, I think we may have 4. Some of those are repeats, if I'm reading this right.
Yeah, that's wrong.
The, well, if you look at the first page of felonies,
Uh-huh.
she was sentenced to 12-month parish. That's not, it's called parish prison, but I think that's actually a misdemeanor.
Okay, so
And
let's,
so that one I don't think would count. On the
Okay.
second page, if you look at the first conviction, which is 1, 2, 3, 4, 5 down. That's
well, the very top one is
okay, yeah, that one's one.
a year in Department of Corrections.
And then the next one is number 5 down. That's the same one, I think, as 1, 2, 3, 4 down. That's the same amount of restitution, same time sentenced. And she said that was all the same case.
This courtroom moment turns fiery fast. Gabrielle Smith expected a 5-year cap, but when her Louisiana record surfaces, packed with felonies, thefts, and jail incidents, the judge is done playing. The plea deal is rejected, her bond skyrockets from $7,000 to $40,000, and the tone shifts from negotiation to confrontation. And let's be honest, Gabrielle's outbursts don't help. This is the part where you realize the courtroom isn't just about legal documents. It's about presence, past behavior, and how you carry yourself under pressure.
And over again. The misdemeanors alone, I've got at least 8 theft misdemeanors, at least 4 stand up.
I'm sorry.
At least
My
4
baby
okay, at least 4 felonies. I'm not going to accept the agreement for a cap of 5 years. I do not think that is appropriate in your case, based on the nature of this offense, based on your underlying criminal history, based on jail incident reports that I've received. So I'm rejecting that offer, allowing you to withdraw your plea. I'm going to reset your case. You guys can negotiate. If y'all come up with something different that the state thinks is appropriate, then I will look at that at that time. You can go back with the bailiff.
I still have my bond. I still have a bond.
You have a, whatever, your bond is set at $7,000.
No, it was 10,000, but you did 1,000 for the.
You said a PSI bond.
Yeah, a PSI
Because
bond.
there was
No,
a question.
I'm withdrawing the PSI bond at this time. I am finding, based on the information that I have received in your pre-sentence report, that is insufficient. And at this time, I'm raising your bond to $40,000.
Ma'am,
You can go back with the bailiff.
10,000. I'm not understanding how.
Well, what we didn't know, and what I didn't know, and what Ms. Molfino didn't know at the time that this offer was made, was the extent of your criminal history in Louisiana.
Okay, well,
So
can I-
go back with the,
Can
go
I
back.
ask you one more question?
What? Yes.
My original charge of assault on a police officer is not a robbery. She told me that I can, get re-indicted for assault on a police officer. I'm not understanding.
Judge, that was also my
Yeah, I'm not.
Hold on.
understanding.
And when someone else, I'll let you talk. And so when someone else is talking, you let them talk. All right? That's respectful for everyone. I gave you an opportunity to let Ms. Molfino answer.
Judge, in my review of the file, I think the case can be charged as either one. Obviously, with her criminal history, would show the amounts of theft. This was an instance that was underlying of a theft that either got out of control and could be indicted as a robbery or an assault on a public servant. They're both the same second degree.
Right.
we will also, if we can't reach an equitable agreement that the court agrees with, be moving to use those Louisiana prior to.
What a ride. From plea bargains and probation battles to explosive criminal histories and immigration complications, this courtroom session had everything. The judge showed no tolerance for manipulation, emotional pleas, or half-truths. Justin Living's story ends with 10 years behind bars and a harsh reminder that the justice system doesn't forget. And Gabrielle Smith? She learned the hard way: what you hide in one state eventually comes to light in another. So what do you think? Should Justin have gotten probation? Did the judge make the right call rejecting Gabrielle's plea? Drop your thoughts in the comments. Like this video if you found the breakdown insightful, share it with your true crime or legal drama crew. And don't forget to subscribe for more jaw-dropping courtroom showdowns like this one. Until next time, stay sharp, stay informed, and stay out of trouble. Welcome to one of the most emotionally complex and legally intense courtroom moments we've covered yet. This is the case of State of Texas versus Catherine Welch, a woman standing before the court not for her first, not for her fifth, but her 10th DWI. But this isn't just another case about repeat offenses. What you're about to witness is a courtroom torn between accountability and compassion, between public safety and personal redemption. Catherine Welch's story spans years of addiction, trauma, and recovery, and her defense makes a bold, rare request: probation instead of prison, despite a long and painful criminal history. Her attorney lays out years of rehabilitation work and mental health breakthroughs. But the prosecution? They're not letting the past go that easily. And then the judge delivers a gut punch of a ruling that no one in the courtroom will forget. So stick with us, because by the end of this video, you're going to be questioning where the line is between punishment and progress. Would you give someone a 10th chance, or would you draw the line right here? Let's dive in.
State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated, third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report. And has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Smallfino, you've had time to review it as well?
Same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talk about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything.
Let's pause here. What we're hearing now is the judge confirming everyone has reviewed the pre-sentence report, including jail incident reports and a sentencing memorandum submitted just the night before. Why is this important? Because the pre-sentence report gives the judge critical insight into the defendant's behavior while incarcerated, anything from fights to cooperation with staff. These incident reports can sway the court heavily, especially in a case involving repeated DUI offenses. And when the defense refers to the Dream Center, they're hinting at a rehabilitative option that's typically used in place of incarceration. This signals what's coming next: a direct appeal for treatment over punishment, rare but possible. But here's the tension with a criminal record like Catherine's: is that enough?
I guess almost 4 years as a project for me, if that makes any sense. And what I mean by that is,
This is where things shift. The defense attorney isn't just presenting facts, he's making this personal. He says, "I took Catherine on as a project." That's a huge statement from a legal professional. What follows is a laundry list of recovery milestones: 90-day inpatient treatment, trauma counseling, outpatient rehab, AA meetings, self-initiated sobriety tools, everything you'd want someone to do to change their life. But here's the question for you. When does effort outweigh the record? Can we measure someone's progress more than their priors? Drop your thoughts in the comments. Would you trust someone with this level of personal transformation, or would the history still make you nervous?
Detail on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report if she felt she needed treatment, she said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means.
Now here's a key legal nuance. The defense clarifies that Welch wasn't refusing treatment. She believed certain addiction-focused programs didn't fit her current stage of recovery. That might sound like splitting hairs, but in sentencing hearings, even small miscommunications can paint a misleading picture. Especially when dealing with probation eligibility, the court has to decide whether treatment is still necessary or if the person has already done the work. Also notable, most private rehab centers won't accept someone who's been sober for 3 years. That's the irony. The more progress you've made, the fewer recovery resources are available. It's a tightrope walk, and the court is watching every step.
Willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position.
This is one of the most humanizing moments. Welch's attorney acknowledges the emotional and financial toll her past has taken on her husband and family. It's a rare moment of vulnerability in a legal argument. And this matters because the judge isn't just sentencing a defendant, they're making a decision that will ripple through an entire family. But that begs the question, should family support factor into sentencing? Does being loved or supported mitigate repeated crimes, or should the legal system remain blind to all that? Your take? Drop it in the comments. We want to hear from you.
For me, as a representative of Jefferson County and the state and the citizens that were on the roads every day, to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out.
Now we hear from Catherine herself, and this is powerful. She admits her past was fueled by addiction, but what stands out is her understanding of her mental health conditions, bipolar disorder, PTSD, and how untreated trauma drove her choices. What's different about this testimony isn't just the regret, it's the specificity, the trauma-informed care, the AA groups, the job she held while in sober living. This isn't a generic "I'm sorry," it's a structured case for rehabilitation. But even with all that, is it enough to outweigh 10 DWIs? This is where the courtroom tension reaches a peak.
Drugs and alcohol, I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain, just numb myself out. I didn't know how else to deal with that until when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in Spring, and I worked there until I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right at a year. And I'm sorry, I'm very nervous today, and I know that my past record is like Ryan said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot, and I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, Ms. Malfino probably said it yet best. And
This is where the gavel drops, metaphorically and emotionally. The judge starts with empathy, but then delivers a brutal reality: 10 DWIs, repeated parole violations, multiple revocations. It's not just about past mistakes, it's about public safety. As the judge says, "We're just lucky you haven't killed someone." Even with years of recovery, the court cannot ignore the pattern of harm. Here's the legal takeaway. At a certain point, even the best rehabilitation story can't undo public risk, and that's what sentencing often comes down to. Let us know, was this ruling fair? Could there have been another path?
8th, it's the 10th. And while I understand the trauma that you went through, that you've been to SAFE 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI, that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 year, back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one, so they give you 15 years, and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess.
So there you have it, a rare case that pits human transformation against legal accountability. Catherine Welch made remarkable progress in her recovery, but the court couldn't overlook her extensive history, and ultimately sentenced her to 18 years in prison even after waiving the habitual offender enhancement. This case lays bare the hardest question in the justice system: when is someone truly rehabilitated? And when is it simply too late? The prosecution didn't dispute her growth. The defense did everything right. But in the end, the court sided with public safety over personal change. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We break down the drama, the law, and the life-changing decisions, one case at a time. Welcome back to the courtroom. Today's docket isn't just serious, it's stacked. We're kicking things off with Mr. Batiste, who's facing not one, not two, but 3 felony charges, including 2 murders. And it gets worse, he's got prior convictions, which means the stakes are sky high. The judge lays out an offer: 45 years if he pleads guilty or potentially life if he goes to trial. But Batiste, he wants to roll the dice. We also have a probation case that spirals fast, multiple violations, new charges, and a judge who's had enough. And just when you think it couldn't get more intense, a 19-year-old with a fight record longer than his sentence gets a chance at redemption, but only if he plays by the rules. Stick around, because this one's about second chances, courtroom tension, and high-stakes decisions that could change lives forever.
Second, Mr. Batiste, in cause number 24, DCCR 0407, charged with the state jail felony offense of possession of marijuana from October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand? So again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with the first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same date. And what that means in those 2 cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced. The minimum punishment would be 15 years in prison.
Now here's where the legal gravity really kicks in. The judge isn't just reading charges, she's calculating futures. Because of Mr. Batiste's prior convictions, his potential sentence jumps from the regular murder penalty to a minimum of 15 years, up to 99, or even life. That's what's called a sentence enhancement, when prior felonies stack the odds against a defendant. The court's not offering this lightly. And yet, even knowing all this, Batiste is still choosing to go to trial. Bold move, or reckless gamble? What would you do? Take the plea deal or risk the rest of your life on a trial verdict?
Same time. Do you understand the possible consequences if you go to trial, and what your options are if you wanted to enter pleas of guilty? And do you want to reject those offers and have all of your cases set for trial? Okay, we'll get those cases.
So Batiste officially rejects the plea bargain, and here's the kicker. The state has already filed a motion to consolidate his 2 murder cases. That means 1 jury, 1 trial, twice the evidence. This is a strategy that works in the state's favor, especially if the charges are similar or stem from related incidents. Prosecutors want the jury to see a pattern. For Batiste, this is a serious gamble. The more the jury hears, the harder it gets to separate one charge from another. Are his attorneys making the right call here, or should they have pushed harder for a deal?
True.
Separate days.
Right. Okay, so you want to reject those offers and have all of your cases set for trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way there's no worries when we get to a trial of going forward or not.
And
All right.
Judge, I don't know if Mr. Coleman has decided on behalf of the state if he plans to try both of the murder cases together. The marijuana is a separate, totally separate incident, and whatever happens with that is what's
I
going
don't
to happen.
think that's the concern.
Next up, Tyron Henderson. This isn't just a probation hearing, it's a slow-motion train wreck. He was already on probation for 3 offenses, then racks up new ones while still under supervision. We're talking about evading arrest, reckless driving, failing curfew, missing fees, basically violating every rule in the book. And the judge? She's clearly running out of patience. Probation is meant to be a second chance, but Henderson seems to treat it like a suggestion. Do you think people who violate probation this consistently should get another shot, or is the judge right to cut the cord?
Property In cause number 21-38934, on probation for evading arrest or detention with the use of a vehicle. And then in cause number 22-39131, on probation for unauthorized use of a vehicle. There have been motions to revoke filed in all three of these cases. Mr. Rennick has filed motions asking that I set bonds. Okay, so the theft of property is a straight probation. These other two are both deferreds. So just by the nature of looking at the dates, without getting too far into this, it appears that he was on probation for the evading and the unauthorized use, and then received another probation while he was on those for the theft of property. Is that correct?
That's correct.
And those other ones were continued
Yes, that's right.
after that violation. Okay. And there are no bonds set at this time. Mr. Smith, I'll get to you, Mr. Rennick, real quick, but what is the state's position on bonds?
The only concern I have, Judge, is the fact that he is on probation and committed a new felony offense. In fact, he was on probation, got deferred, and has committed a new offense.
So in those motions, the allegations are, one, a new arrest for evading arrest or detention with a vehicle, an arrest for reckless driving, both of those from March 23rd of 2025, failure to provide verification of community service, out past curfew at 3:35 a.m., behind in his fees, and restitution. All right, do you want to call your client?
Judge, I don't want him to justify
Okay.
about anything. It's just basically our position is with this is that he has a home structure, he realizes he's messed up, he realizes he hasn't done his probation. We're just really asking the court to set a bond. He does want to show the court that he can comply with probation, get his classes done, his hours done. He has 3 clients.
I'm not worried about classes or hours. I'm worried about the fact that you're still getting arrested for the same thing that you're on probation for. And you've already been put on probation and given an opportunity. You violated the law. You got another opportunity, and I continued you, and now there's some more violations.
This ruling is a turning point. The judge denies bond in all of Henderson's cases, and she doesn't sugarcoat it. Evading arrest with a vehicle is not just reckless, it's dangerous. She points out the risk to the public and officers, making it crystal clear this isn't just about breaking rules, it's about putting lives at risk. Judges don't revoke bond lightly. This is a calculated move to protect the community. Henderson's defense team now has to regroup. With no bond, he'll sit in jail until trial. Should repeat probation violators even get another shot, or is this the wake-up call he needs?
In any of your cases, we will set these for whatever y'all want to on an announcement. If he's going to plead not true, we can have a hearing first on the motions and then move forward on the trial later if that's the...
Judge, with that ruling, what I'm going to do is I'm going to try to get Mr. Smith this week and see if there's something we can do to work this out quickly. So
Okay.
Just get something figured out as quickly as we can.
Okay, sounds good. We'll do a normal reset at this time. If something happens prior to that, just let me know. We can always move it up. You can go back with the bailiff.
Now let's talk about Mr. Strickland, a 19-year-old whose fight record in jail is so bad even he can't remember all of them. The judge straight up calls him out multiple fights, sneaking into bathrooms to avoid being caught. It's like Fight Club County Jail edition. She's seen enough. And yet, despite the chaos, she still wants to help him succeed. That's the surprising part. This isn't about punishment anymore, it's about intervention. The judge pushes for ISF cognitive therapy, a last-ditch effort to change his trajectory. But let's be honest, will it stick? Or is this just a pause before another round?
Have y'all both had an opportunity to review those?
Yes, Judge.
I have, but I don't remember.
4 fights.
Yeah.
Oh, yeah.
You like to fight, don't you? You don't? You don't? Okay. I can tell you that I have people in front of me all the time, and they're not doing what you're doing. Constantly fighting. And the way these reads, it does not necessarily show that you weren't the aggressor. It doesn't show either way on some of them, but it looks like these were some pretty mutual things going on, specifically finding places to fight, getting in the bathroom to fight so you can't be caught and all that kind of nonsense. How old are you?
19.
19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days up front. I don't know that jail necessarily is as useful as potentially something like ISF, cognitive track, because of its age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going, you're not going to be. The conditions of your probation are always up to me. So I can give you what I want as a condition, anything that makes me feel like it would be.
This is where things get real for Strickland. He's sentenced to 10 years and 2 years in prison, both probated, meaning he's serving time on paper unless he slips up. And with his history, that's a big if. The judge's conditions are crystal clear: complete the ISF program, stay out of trouble, follow the rules. But here's the thing, any slip-up, even a jailhouse scuffle, triggers that full sentence. That's the gamble he just took. At 19, he's being handed a lifeline. But is he mature enough to use it, or will the next time we see him be behind bars again?
To pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0209, find sufficient evidence to find you guilty, and at this time follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison, but probate that. You'll be on probation for 5 years in that case. I don't have a fine. Is there no fine in that one? The 1,000 and the others probably.
It was just one fine.
It was just
Okay.
one fine in one case, Judge.
Okay. So in each of these cases, you're ordered to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete the cognitive track of the ISF program. It's a 90-day program. It's in custody. You'll be transported from our jail to there fairly quickly. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then going to prison. Do you understand? If you get in trouble now that you're on probation, if you get in trouble in the jail, get in a fight, if you get in trouble at ISF and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go to prison, okay? All right, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker, okay? Good luck to you, sir.
What a roller coaster. We saw 3 defendants, 3 vastly different situations, and 1 unflinching judge. Batiste rejected a 45-year plea deal and now faces life, with 2 murder trials likely consolidated. Henderson burned through multiple probation chances, only to lose bond entirely. And Strickland, at just 19, he got 1 final chance with probation and court-mandated therapy, but the sword is still hanging. These cases show us the full range of courtroom reality, calculated risks, legal consequences, and rare opportunities for redemption. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real drama, real rulings, and real consequences coming your way.